bring along tonight?
I brought along tonight Martin Seib from
Marty.
Loosedale.
What's up, buddy?
And he's great. He specializes in this area of the law along with criminal law. And so he's going to be fielding a lot of questions tonight.
I'm going to try to.
Marty, we were talking before the show. When you do a show like Love and the Law, you got to have Jim. And you got to have you, because Jim knows a lot about love, as he's already expressed here tonight. But you got to have somebody on your side of it, too, that does the family law side. How long have you been at practice now, my friend?
About 10 years now.
10 years. That's impressive. We were talking beforehand, before the show got started, and you brought up an interesting point about when a divorce goes through, parents agree to terms. And it does seem like as the length of the divorce goes on, the sides sometimes decide that they're gonna make their own decisions about the judge's orders, and that's just not the way it works, is it?
That's a common question that comes in the office. If you get a court order, you have to follow that court order. You cannot just mutually modify that court order without having to go back to court. And a lot of parties find themselves in difficult situations when they modify that court order. They're going to do whatever they want to do. That's when you're looking at contempt actions being filed against you. If there's an issue that is that severe, take it to court and let a judge hear it, and that will give you the protections and make it an enforceable matter with the court order.
And as a
I can see it happening,
well,
too.
it happens all the time. You know, maybe when you're getting along with your ex, you agree to something that's different than what is in the judge's order, and that all works fine. But sort of, when the hits the fan, then the other spouse comes in and says, well, you've been violating the court's order, and the judges do not like that. So if you have significant changes in either child custody, child support, you need to go back to court. Not necessarily always need a lawyer, but you need to have the judge's blessing in terms of what you're changing.
If I was in a car accident 3 years ago, am I still entitled to compensation? I never signed off on an injury claim. She might be pressing the deadline here a little bit.
She is pressing the deadline. So a couple things here. If you haven't signed a release, then you do have a viable claim if the statute of limitations hasn't expired. In Mississippi, generally the statute of limitations is 3 years, and a personal injury claim can be as short as 1 year, depending on the circumstances and the defendant. So we talk about this all the time. If you think you've got a claim, you can't sit on it. 3 years, I would call an attorney Monday morning and talk to him about the date of your accident, see if the statute of limitations has expired. You should never wait 3 years to enforce your rights. Even as a practical matter, if you can bring the claim, evidence is gone, witnesses disappeared, makes the claim much more difficult.
You'll never need a workman's comp claim benefit, but if you do, what should you expect your check to look like? Personal injury attorney Matthew Medier has an answer in tonight's legal brief.
Workers' compensation laws are designed to compensate employees who've been injured in work-related accidents. In Mississippi, any business with 5 or more employees is required to carry workers' compensation insurance. So what benefits are those employees entitled to? For injury claims, multiply the employee's average weekly wage by 66 2/3%. Benefits are paid regardless of whether the employer or employee is to blame for the injury, and you're not required to pay taxes on these benefits. Even if you don't think you're injured, immediately notify your employer or supervisor about any accidents. In most instances, if you fail to notify your employer within 30 days of the incident, you may lose your workers' compensation benefit. By placing your employer on notice, you're protecting yourself in case you need medical treatment later on. I'm personal injury attorney Matthew Medier.
What can we help you with?
Yes, hello, good evening. I have a question concerning custody. Never married mother, paramount parent, and of course, I'm calling on my son's behalf. This is about his son. And he's been denied visitation. They, of course, had a court order for joint custody. And the child has basically been withheld from my son for some 6 months and so on. Is there any kind of local hotline or anybody short of actually going out and hiring an attorney and so on, is there any quick solution? Could I call the judge?
Bruce, I think you're touching on a couple things that Marty kind of alluded to a little bit earlier about the judge's order, but let me throw it over to Martin on this one.
You brought up about 6 or 7 different critical points. Number one, do not call the judge. That's considered ex parte communication. You're going to put the judge in a bad spot. You're not going to help your case out in any way. If he has visitation and it's court ordered, the other party has to adhere to that court order. They cannot stop visitation because you're not paying child support. They cannot stop the visitation for any other reason. If there's an emergency issue, they can go to a judge and file something and get a court order stopping that visitation. The only way visitation can be stopped is if you are proven unfit. And that's a very high burden to prove. Drugs, criminal activity, domestic violence charges, things of that sort would establish those grounds. To get to your question, you can file something yourself to try and enforce the visitation. If you're doing a contempt proceeding and you're seeking incarceration, that's a different matter. There's a lot of procedural safeguards that need to be followed.
Right.
You would probably need to hire an attorney.
Right.
But if you're trying to just get your visitation established, you can do that. If you want it done correctly the first time, though, I would seek going and getting legal help, because if you've gone 6 months, the longer you go without that visitation, it makes it harder for you to get back in and maintain those meaningful relationships between a parent and the child.
And that's just what he was saying earlier, wasn't it?
Yeah, same thing. And short answer is you can do it without a lawyer. If you absolutely can't afford a lawyer, you can do it without a lawyer. What you're essentially doing is going to the judge and saying, make her do what you've already said she's supposed to do. And the judges will enforce this, but you've got to get it in front of them and ask them to do it. And that is really in itself not a complicated procedure necessarily, but he's right, you've got to do that quickly. So I'd get on that Monday morning.
And then, Jim, like you were saying, it was earlier, you just can't wait on these things, can you?
No, as a practical matter, you don't want to wait on them. If it's a child involved, and 6 months is a long time in the life of a child who's growing, and you don't want to be out of their life for that period of time. And so I would move on it very quickly.
I was calling because the other night I heard my parents arguing, and they kept saying it was their fault and it was the other one's fault. And then I saw a sign the other day for a no-fault divorce, and I was wondering what it means.
Charles, it sounds like you are in right in the middle of it, my friend. I feel for you. I suspect, Marty, when the term no fault comes up in a legal term, it means probably a little bit more than what Charles is talking about with his parents here.
In Mississippi, to get a divorce, there are enumerated grounds, 12 of them to be exact. And of those 12 grounds, one of them establishes an agreement between the parties that they wish to be divorced. They have to have an agreement on all issues. Division of assets and liabilities, which is called equitable distribution. You have to deal with custody, visitation, and child support. And you have to do the necessary paperwork, get it into court, allow a judge to enter an order.
Right.
That's an agreement between the parties. It doesn't require proof of showing adultery or drug use or
parents yelling back and forth at one another.
Correct. That's called habitual cruel and inhumane treatment, things of that sort, where they just come to an agreement between the two of them that they need to go their separate ways.
Right.
And at that point, if they come in, they answer some questions to the judge feels satisfied by it, they will grant the divorce.
The state legislature is looking into changing or modifying the law about abuse and cruelty in a marriage. Is it complicated? Is it moving ahead? What are your thoughts on it?
One of the things that they're looking at trying to do is reduce the burden of proof that the party claiming the abuse has to prove.
I see.
A lot of times, if you have somebody that is verbally or physically abusive to a spouse, they typically do it in private. It's not something that they're broadcasting out there.
Right.
In much the same regards as adultery is typically done behind closed doors. So you don't necessarily have to walk in and catch them in the act with a camera to be able to prove it in court. They're trying to do the same thing for individuals that are suffering from perpetuated abuse, to try and give them a better avenue to be able to escape those and find some safety. So I think that the legislature is moving forward on that.
Okay.
We're hoping to get some final results on the bills as they come forward. And
Jim, how does that work on y'all's level? Is that something when as lawyers, when y'all see changes that need to be made in law, do y'all go through the Bar Association, or do y'all how does that work?
Well, we're actively, different lawyers, I guess, do it different ways, but we're actively involved in lobbying and interaction with our local legislatures and the people in the Capitol. And so my understanding is that bill and amendments have a really good chance of going through this session, and we support them. We think they're good legislation. You have to really watch what you're putting on your social media. It's commonplace in every case now that you do a thorough background search on people bringing a claim and defendants. And I can't count the number of times that I've had things come up on social media that help out in the case or either hurt my case. And so you have to be very careful, and we caution our people, what goes out on the internet usually is there forever. So be careful, particularly
Until
if
next
you have a
Saturday night, 10:30, we'll be broadcasting live here, taking your legal calls and questions live on the air. But until then, good night.